confusion, I think, between what someone's estate plan actually does for them versus what they think it does for them. And so you want to make sure you're using the right tool for yourself and your own situation. And sometimes wills are the right tool for some people, and sometimes trusts are the right tool for people. So it really depends on your situation. And we're going to be talking about the differences in how they work and in the and which one may be right for people. But again, welcome. I'm attorney Justin Randall with Hooper Law Office. Welcome to our wills versus trusts topic today. To get started, just to let you know, if you're participating via Zoom, you will be able to ask questions during this, and there's a Q&A function that I can see the questions pop up and should be able to answer them, assuming I see them come up, and I will mix it a little more interactive for you. If you signed up via Zoom and you are watching this that way, you will be receiving a feedback form at the end of this via email. It just allows you to, say there's things that we could improve on, or if you really thought it was great, or whatever you feel like feedback-wise putting in there. But it also allows you, if you would like us to reach out to you to set up an initial consultation, that is a place for you to fill that out as well. And our initial consultations are complimentary. We don't charge anybody anything to come in and talk to us initially, so that we can really sit down and get to know your situation as thoroughly as possible to give you the best recommendation. If you like this topic, our topic next week is about our very popular more information on what to, how probate works and what sorts of things people are going to need to be aware of when they go through probate, or if they're acting as someone's personal representative for their estate. It's been so popular, and we've gotten a lot of questions on it and been very interactive during those webinars. So we've decided to do another one to try to get through more of the information. If you don't see the Q&A function come up, there is a way. There's a box at the bottom of your screen that or kind of a dotted line that should allow you to open up the Q&A box too. All right, so to get started, I won't be talking too much today about powers of attorney and things like that, mostly because wills and trusts themselves, they're pretty in-depth topics. So I want to devote as much time as possible to those. And we do other webinars related to powers of attorney and things like that. So that is just, it wouldn't have enough time in this 30-minute time span to talk about all of that today. But to get started, when people look at doing their estate plan, one of the biggest misconceptions that they may have is that, well, okay, I've heard wills are for this type of person, or for someone with an estate this size, or, versus trusts are more for people with an estate over a certain amount. And, it's only for, wealthy people, is kind of the big myth that a lot of people perpetuate about trusts or hear about trusts. And that's just not really the case. Whether you use a will or a trust for your plan is going to depend way more on, the process you intend for your estate to go through after you've passed, your family situation, some of your concerns. Those are way more important in determining whether a trust or a will is right for someone over how much money someone has. It can play a factor, but it is not the most important factor by any means. So with wills, the biggest misunderstanding people have is thinking that, oh, I have a will, so that means my estate will avoid probate. And that is unfortunately not the case. So wills are specifically instructions to the probate court of how you want your assets to be divided, amongst your beneficiaries, who you want to be in charge of the estate. If you have minor children, who you want to name guardians as guardians for those minor children. So it is specifically something designated to the probate court. Wills don't have any jurisdiction over things avoiding probate, which can create a huge problem for a lot of people with their estate plan, for example. So that's just something to keep in mind when you are looking at which tool is right for you. This misconception with wills can create a lot of problems for people with their plans. A lot of times what we'll see is somebody had a will done, years ago, for example, or, they had one done by maybe an attorney who doesn't necessarily focus on this area of law. It was sort of something they did as, part of another matter and just kind of helped them get a will in place. And they think they're covered. But then when you actually look at everything in their estate and what their intentions are, a will wasn't the right tool. So with wills, like I mentioned, since they only control the assets that go through probate, if you have certain provisions in your will about, well, here's how I want my estate to pass, or I have certain types of trusts set up for my minor children in that will, or I'm providing for a child with special needs, and so there's special needs trust provisions in there. If you want those to actually work and want things to go according to your plan, you also need to make sure that the assets of the estate go by the terms of that will or are properly aligned with the will itself. And what I mean by that is, more often than not, when people have a will, most of their financial assets avoid probate. They put things on their accounts like beneficiary designations, payable on death or transfer on death, listing those people as beneficiaries of those accounts, in particular things like IRAs and 401ks and life insurance have those types of, beneficiaries on it, but checking accounts and savings accounts, those have those on there, or the ability to put those on there as well. Another thing is joint ownership can, if you jointly own an account with someone else, that can disrupt that plan. If your intention was to pass everything to your kids equally, but then you put the one kid on there as joint owner, banks, I've often give our clients that advice as a way of saying, well, this is a lot easier for them to get access to it. And, if you have a good power of attorney, it's unnecessary, but two, they're not factoring in that when you have joint ownership on an account, that doesn't go by the terms of the will. It may not go to those children equally. If you had 3 kids, but only one is on as a joint owner, that account actually becomes the joint owner's account upon the death of the other owner. It does not go by the terms of the will. So those types of things are really important to be aware of when you have a will and you have certain provisions in that will that you want followed. Another thing, and this is something too that we will talk about a lot more in detail next week with our probate topic, but what happens a lot with wills is somebody has primarily the home going through probate or some sort of real estate that they own going through probate, because it doesn't have a beneficiary designation on it saying, it's payable or transfer on death. Those types of deeds exist, but most people don't have them. You would generally intentionally set something like that up. It wouldn't be something that you just kind of think you have. But so, it's usually the home going through probate, but then if people haven't properly aligned to their other financial assets to make sure that they go by the terms of the will, it may be that the executor or personal representative of your estate doesn't actually have access to the funds of the estate and not any source of funds to pay for ongoing expenses of the home, realtors fees if they're trying to sell it, property taxes for, the ongoing year that, maybe the probate is taking for your estate to be administered. So you want to make sure that at least some amount of money is available to the personal representative of the estate. And that is the executor, for those of you who are not familiar with that term. It's just what we in Wisconsin call the executor. So having some amount of money go through probate with the home is very important to make sure that some amount of cash, liquid assets are available to pay for the expenses, or if there's a mortgage, potentially satisfy the mortgage, so that the beneficiaries don't have to either sell the home or assume the mortgage. You want to have that available, but whether or not every ounce of money goes through probate when you have a will, if you have some sort of trust set up through that will for minor children, or like I mentioned, a beneficiary with special needs of any kind, you want to make sure that you're intentionally directing those assets to go by the terms of that will, and not just, assume that everything will be covered by the will. It happens a lot where somebody will name, for example, when they have a child with special needs, they'll set up, like I mentioned, that special needs trust or supplemental needs trust, depending on the terminology the will uses. And that prevents that child with special needs from losing their benefits when they inherit money. So it doesn't go to them directly, and doesn't count against them for means tested programs. But if you then just name that child with special needs as an outright beneficiary or payable on death on an account, that will not properly fund that supplemental needs or special needs trust. So it happens a lot where people mistakenly think that their plan is just going to kind of grab everything and go by the terms of the trust, whereas they unintentionally avoid the actual proper and careful planning that they may have put together. So that is, with wills, the most important thing to be aware of when you are actually intending to use it. If you have a will, but then you have nothing going through probate, you're not really doing yourself, and you're using the will as your main plan. You're not really doing yourself any favors. It's not really helping you in any way. And so I always sort of jokingly, but in all seriousness too, tell my clients, if you're paying me to put together a will, you should intend to use it. You shouldn't, purposefully avoid using your main controlling document of your plan after you've spent money setting it up. It just doesn't make any sense. So you want to be very careful about how you direct your assets. And that goes the same with the trust as well. So wills only go through probate. They only direct assets that go through probate. And there are some reasons that people want to avoid probate. They want to use things like beneficiary designations so that their assets don't go through probate. And the question becomes, well, why might somebody want to avoid probate? Probate kind of has this like boogeyman status where people hear that term and they get really, oh no, you never want to go through probate. But in reality, there can be perfectly valid reasons to go through probate. So just to give you a quick explanation, probate is the process in which somebody's estate is handled by the court and divided up following the terms of the will for the assets that are subject to probate. It's how that gets administered after someone passes away. That's what probate is. And it's a way for creditors to be paid off, all of that. So why might somebody want to go through probate? Well, one, if you have minor children, the only place that you can appoint guardians for them should something happen to you, and that you can nominate those guardians, is in a will. So that means you may need to use some level of probate if you are passing away and you have minor children. You want to appoint guardians in a will. I've seen people I've seen trusts that say, here's my guardians for my kids, but certainly not any I drafted, but from other firms I've seen it, and that just doesn't do you any good. That's not the place to appoint guardians. A will is the place that you nominate those guardians so that the court can approve them at that time, because the court has to approve them at some point. So minor kids, perfectly valid reason to have some level of probate occur. Another is if somebody has a deficit estate. That is another good reason to go through probate. A deficit estate means you owe more money than your net worth. Your net worth is negative, I should say. You owe more money than you have. So at that point, probate can function sort of like a bankruptcy for the estate. It gives a place for those creditors to make their claims, come forward, once they've been given proper notice and all of those requirements are out of the way. They can, get their money in terms of priority. So if somebody has, higher priority than another creditor, they may get paid and the other creditor may not. But if there's not enough money to pay off all the creditors, then that's where that sort of bankruptcy function comes in and says, okay, they've paid out what they can. There's nothing left. Sorry, other creditors, there's not enough for you. And so that just makes sure that those claims are taken care of properly, that the personal representative, or, again, interchangeable with an executor, that they've followed their fiduciary obligations in that role and that they've done everything properly. So in those circumstances where somebody does have more debt than assets, probate can be a perfectly acceptable tool to use. It's where you would want to be so that the court can oversee everything. A third is there are certain types of trusts especially for like long-term care planning and Medicaid planning for surviving spouses that can only be set up by a will. So there are perfectly valid reasons that somebody, maybe needs to go through probate in order to fund a certain type of trust. So it's not going to be the case for everybody, but that is an example of when you would potentially want something to go through probate and you don't want to avoid it in that, that circumstance. But people often don't want to go through probate because of what they've heard. And there are a lot of reasons why somebody just may not need probate of any kind for their estate. It's just not the right tool to use for them. And that is more often than not because of the length of time that it takes. People don't want to have an estate administration take that long. It usually, ballpark estimate kind of around a year to a year and a half is the standard range, I would say. Can take longer than that if there's any sort of disputes or, if depending on how complex the estate is and, if there's any sort of reason that the court needs to extend it, it can be extended longer. It would be, almost unheard of for it to be much shorter than that, mostly because of the length of time that some of the creditors are given, to come forward. So it's about a 90-day period of time where creditors are given the opportunity to come forward. So you've already got 3 months in there just for one of the first steps. So it takes a lot of time, and people generally want it to be over as quickly as they can. They're already grieving. It's already a hard, situation for someone to be in. So that time component of it can be a big reason that people don't want to use that process. Another is that probate is generally more expensive for an estate than using a trust in the long run or avoiding probate. And the reason for that is probate is a lot more work on the attorney side. It's generally more time involvement. So you're going to see higher attorney's fees from probate than you would over administering a trust. And that's, I can't speak for every firm out there, certainly, but most firms would probably charge more for a probate than they would for a trust administration. So expense is a big factor. Another is that probate is actually completely public record. And that can be a really good reason why somebody would not want, a probate to occur. They don't want any sort of public information about their assets out there, or especially if you have minor beneficiaries and assets are going through probate, people can see who the beneficiaries are, and that's where you sort of hear about these kind of, quote unquote investors coming forward and saying, I have a great way to help you spend that money, or I can show you how to invest to a young kid. And you don't want minors being taken advantage of in any way, even though those minors won't actually have direct control until they are age 18. You also don't want an 18-year-old to potentially be coerced or manipulated in any way when they just don't have enough life experience to know what good investments may be, or how to properly manage expenses and all of those things. You don't want those people who are at risk of that manipulation to, you don't want to open up that information so that more people have a chance to manipulate them. It's the privacy is a big concern for a lot of people, especially these days. So that can be a big reason people don't want to go through probate too. So when we talk about probate avoidance, then that's where you hear a lot of people talk about, well, okay, as I mentioned earlier myself, beneficiary designations, payable on death, transfer on death, things like that, those avoid probate. They pay directly to the individual you've listed, or individuals that you've listed. But the problem with using beneficiary designations as a plan, there are certainly really good tools to use, and sometimes you have to, but they're tools in a toolbox. They're not a plan in of themselves. The problem with using them as a plan and not having a will or not having a trust and having nothing else in place to take care of that is it's on, it's different on every account. So you have to go account by account to update those beneficiaries. And anytime you make a change to those, those beneficiaries, if you want it to be across the board, you have to do it to all of the accounts, not just in one place, like in a will or a trust. Another problem with using beneficiary designations is that if somebody has a will or a trust, or they have any sort of creditor expenses or anything like that coming up after they pass, final expenses, paying out to those individuals directly, the person managing that person's estate, so the personal representative or a trustee, depending on the documents they're using, those beneficiary designations, the beneficiaries who have received those funds are under no obligation then to give money back to the person managing the estate at that point. So it can be really difficult if you put someone in a position of control over the estate for them to now try to get funds back from people and say, I need you to help me with this. This particularly is a concern when the person managing somebody's estate, the person you've named as a personal representative or as a backup trustee, if they're also themselves a beneficiary, because you think, oh, they may be able to use their share, to pay those expenses. And I know their siblings will pay them back or, reimburse them for their shares of those expenses. And that's hopefully your kids would want to do that. But again, they're under no obligation to do that. So if your intention was for something to be shared equally, but then you're putting it on one person to use their share for those expenses, they may not actually end up as equal beneficiaries when all is said and done. There's also plenty of reasons that somebody who may want to help out the personal representative with those expenses may not be able to if they themselves are on any sort of means tested government benefits, or if they are on Medicaid or anything like that, where if you gave money away, you might not be able, that might cause them harm then, because when you gift something away and you're on a program like Medicaid, you can lose your benefits temporarily. And that is not something you want to put on somebody else to make that decision to do. So, it's just those kind of multiple places that those accounts are going and not kind of being pooled together initially before they're distributed to the beneficiaries does not give the personal representative or the trustee the best access to just a pot of money to make sure those expenses are paid first before anybody gets anything. And that way you guarantee that what you wanted as your plan, depending on what percentage or fraction people are inheriting in, that's actually how people inherit, and that somebody doesn't unfairly use more of their share for those expenses than someone else, because then that's not your intended result. So that's a big issue. But another is that if you name someone as a beneficiary on an account, like I mentioned earlier, it just pays to those people, but it does not account for any sort of unforeseen circumstances that can come up when somebody has beneficiaries who maybe have children with special needs, or are, have a disability that was not foreseen when those beneficiaries were named, or potentially develops a substance abuse issue, any of those sorts of things that can happen during someone's life. Beneficiary designations don't account for those. And they're, like I said, they pay directly to those people. So if any of those things are happening to somebody, when they inherit, that money is at risk, and potentially the beneficiary will be harmed if they had benefits, or they may harm themselves with that money if they have any sort of substance abuse issues in their lives. So that's something to be aware of as well. When you have a will, you can put designations in there and backup structures in there that say, should anybody in any of these situations inherit from me, that they'll inherit in a way that does not cause them harm. So that is where you want to actually specifically use the will that you've set up, if the will is your main plan. So, the question becomes for people then, well, okay, well, I really want to avoid probate, but I still want to make sure that all of those sort of unforeseen circumstances are covered, and make sure that, the person managing my estate has what they need to pay for expenses, and not have to kind of try to claw things back from beneficiaries. and I want to make sure that my plan is followed. How do I do that and avoid probate? That is where trusts tend to come in a lot more frequently for than wills would these days, I would say. So when you're looking at using a trust, the trust functions a lot like a will in that it has the terms of how you want your estate to be divided. It puts somebody in charge of the, managing the final expenses and making those distributions to beneficiaries. It still has that central document controlling everything. And it can also account for beneficiaries who may have had those unforeseen things happen to them, like a disability or, substance abuse issue come up, things like that. But trusts are not subject to probate. So they pass those assets outside of probate as well, in a way that a beneficiary designation would, except with a lot more added protection on making sure that if something unforeseen comes up, that it can be dealt with. It's a really great tool to use if probate avoidance is your primary concern. There's also a lot of things you can do to protect your beneficiaries from in their inheritance from creditors and from divorce and lawsuit liabilities, things of that nature, through a trust as well. So, trusts are a great tool if you're trying to avoid probate. And a trust, just like a will, in this sense anyway, is no good to anybody if it is not properly funded. So wills only control assets that go through probate. You want to make sure that your trust, if you're setting one up, is properly funded. And by funded, I mean that involves titling assets in the name of the trust during your lifetime, or designating the trust as a beneficiary on certain accounts, so that when you pass away, the trust gets funded. You want to make sure that that is properly set up when you or after you have that document drafted, because a trust that doesn't own anything when you pass away or after you pass away is as useless to you as a will where you have nothing going through probate. You need to make sure that whatever document you're using, you're properly using it. And, at our firm, we specifically then make sure that when we set up plans for our clients that, we do that sort of asset alignment, making sure that those accounts are properly designated or owned, depending on the type of plan we're setting up for somebody, to make sure that they actually work as intended. A lot of times what I'll see is somebody did a will online or something like that, and then just didn't update any of their actual accounts. And that, like I said, that's basically a useless piece of paper then at that point. You just want to make sure you're using the plan that you're intending to use. So that's what I meant when I said earlier that it doesn't really matter as much how much of an estate somebody has. You're not looking at, I have $2 million versus this person has $500,000. There's no threshold necessarily that somebody needs to meet before a trust makes sense. It can depend a lot more on whether they want to go through probate or not, on whether they are still trying to make sure that those sort of unforeseen circumstances are met. Okay, so I did just get a really good question. A young family with a sizable retirement account, about $1 million, should the family use a will or a trust? List the contingent beneficiaries, the minor kids, a testamentary trust under a will for them, or a trust. So if it's a young family with minor children, the big thing with a sizable amount of money going to minors can't own property. So any sort of amount of money designated directly to minors automatically has to be set up in sort of a custodial account or an UTMA account, or some sort of managed account like that, so that somebody else has control of it. So one option instead is to then, whether you're using a will for yourself or a trust, is having the kids inherit in a trust through your document. So a lot of times, if there's multiple minors, for example, multiple minor children, and there's a gap in ages, or there's just the oldest is 5 years older than the youngest, a lot of times what we'll do is we'll set up what's called a common trust, where that trust can be used for all the kids until and this changes depending on how you define it, but until the youngest meets a certain threshold. So whether it's well, now the youngest is 25. And so they've all gotten the same level of support from us, where the youngest has graduated from college. You can put whatever threshold you want on it, I suppose. But, well, then with those sorts of retirement accounts, in this instance, with like a $1 million retirement account, rather than naming the kids as the contingent beneficiaries, if you had a will and it set up a testamentary trust for the children, you would then name as contingent beneficiaries that testamentary trust, not the kids as outright beneficiaries. So that would then allow that trust, or the trustee of their trust, to manage those accounts for them, until they reach whatever threshold you've put. It also makes sure that you don't have to then set up an UTMA account or a custodial account. The trust is sort of replacing that. So in that instance, whether somebody in that situation with that young kids, young family, but $1 million retirement account, well, whether you use a will or a trust is going to depend a bit more on like that probate avoidance, if that's your goal. But also with young families, a big thing to keep in mind is that privacy concern with probate, potentially, where you're looking at, somebody, if you're sending an asset through probate to fund a trust, or if you are, having those terms set up through probate, it can be something you want to keep out of the public eye, especially a sizable amount of money going to young kids. It's just something to be aware of that may lead someone in that situation towards a trust, but not always. It really depends on very specific sorts of situations that someone might be in, and what their ultimate goals are. But so I know that was a kind of a long answer to that question, but yeah, you would, in that instance, if you had an account like that, you would not want the kids themselves as the beneficiaries if your document had some sort of trust set up for them, because then that trust won't necessarily get funded properly when they inherit. So with all of that, it looks like I'm getting close to time here. So again, just as a reminder, if you see that feedback form and you have any sort of questions that you want to reach out to us for and set up an initial consultation, please feel free to fill that out. And we will try to set up a time pretty quickly here with you guys. The other thing, just as a reminder, is our next topic next week is more about probate. So I know I talked about it a little bit today, but it is a very in-depth topic that really deserves its own time slot to talk about. So if you have any questions about that, that's a really good webinar to watch next week. And if you have any questions about sort of how those initial consults work, one last thing before you go, that is a really good place where we're able to sit down and give you more specific advice for your situation. With these webinars, it's really great to kind of get some basic questions answered, but it's hard to go too in depth on anybody's specific situation or specific questions because there's so many different factors involved in that kind of advice. So if you have more concerns about your situation that you want a really good specific recommendation on, that's where that initial consultation is a really good tool for you to use. And like I said, they're complimentary. We don't charge you for them. So, that's a really, really good tool for you to use sort of to get that advice. Yeah, so with that, I will let you guys go and enjoy the rest of your day. It looks like a nice sunny day, but please feel free to tune in next week and watch us